Hello, everybody, and welcome to day 3 of our Marijuana Law 2020 conference. We're at panel 6. I hope you've enjoyed the first 2 days. I hope you've checked out some of our panels. It's been a really terrific conversation, I think, on a variety of issues. And today we just continue our conversation. We'll have panels on Massachusetts, lessons from and for Massachusetts, and then later in the day we'll be talking about the environment and energy, as well as criminal justice reform. So let's move right into panel number 6, which is styled Lessons from and for Massachusetts. And I'm going to introduce our 4 incredible speakers first, and then I'll turn it over, give them each a brief introduction, then I'll turn it over to them to take it away. So our first speaker today is Hope Wiseman, who is an entrepreneur who at the age of 25 founded the Maryland marijuana dispensary Mary in Maine, thus becoming the youngest Black woman dispensary owner in the entire United States. She currently serves as the CEO of Mary in Maine and is a frequent consultant and speaker on marijuana policy, equity, and entrepreneurship. She's a board member of the Cannabis Patient Advocacy Association, a patient-based policy organization. And according to her website, her mission is, quote, to continue to kill the stigma the country has created about cannabis within the Black community and help African Americans realize the importance of their place in the cannabis industry. Our second speaker is Kay Doyle, who is the Director of U.S. Public Policy and Public Affairs at the Greenwich Biosciences Incorporated, at Greenwich Biosciences Incorporated. Before that, she served from 2017 to 2020 as one of the inaugural 5 commissioners of the Massachusetts Cannabis Control Commission, where she helped develop the initial set of giant regulations governing the industry in the Commonwealth. Before that, she ran the medical program here in Massachusetts for the Department of Public Health, and beyond everything else, she's also a graduate of BU School of Law. Woo! Adam Fine will be our next speaker. He's the managing partner of the Boston office of Vicente Sederberg, which I think I can safely say is the biggest and most amazing marijuana law firm in America. Maybe I'll get in trouble for that, but I think it's the case. At Vicente Sederberg, he represents marijuana business clients, both large and small. He's a frequent media commentator, oft-quoted expert on just about everything in the marijuana industry. Sometimes I just walk into a panel and there's Adam, like in some other state, or turn on the TV, there's Adam. Among other things, he helped draft question 4 of the 2016 ballot initiative that legalized recreational marijuana here in the Commonwealth. Before that, he worked as a criminal defense lawyer in Philadelphia, where he took part in over 200 criminal trials. And finally, Sean Keely is the clinical associate professor of law at the BU School of Law, where he runs our awesome legislative policy and drafting clinic, oversees our legislative externship program and our semester in practice Washington program, and many other things. Before joining the faculty at BU in 2007, he was a senior lecturer at Suffolk University, where he taught classes on criminal justice and criminology. And among other things, before that, he served as an Assistant Attorney General in the Massachusetts Office of the Attorney General from 1995 to 1999. So I think you'll agree that we have a terrific group of speakers today, and I will now be quiet and I'll turn it over to Hope Wiseman. Quick note, if people have questions as we go along, please write those questions into the Q&A box, and then at the end of all 4 presentations, we'll have a Q&A session, and I'll relate your questions to the panel. So thank you, and take it away, Hope.
Okay, thanks, Jay, for that introduction. Hi, everybody. Like Jay said, my name is Hope Wiseman. I am one of the founders of Mary in Maine, which is a medical cannabis dispensary in Capitol Heights, Maryland, which is located in Prince George's County, Maryland. If you know anything about Maryland or about Prince George's County, it's one of the most affluent African-American counties in the United States. Very proud of where I'm from, and I'm excited to be able to have started my journey here. So I kind of want to kick this off talking to you a little bit about how I got into the industry, why I got into the industry, some of my thoughts about social equity, especially as we know, a lot of states are right now developing laws around their medical program or recreational and medical programs. And now is the time to implement social equity legislation and make sure that it's included. These laws should not be getting passed unless they have these things included. So I want to talk to you about some of my thoughts around social equity. And then from there, I'll talk to you a little bit about my experience and where I think the industry is going. So like I said, I want to start with my journey. So I have a very unique journey, and it has given me a lot of recognition and a platform to inspire young people to go out and reach for their dreams, even if they are in a very alternative industry. Like I said, started in Prince George's County, went to college in Atlanta, Spelman College, majored in economics, and then went on to investment banking. I thought that that was going to be my career path. I was so excited to have started my career in that industry. And my goal was to work my way up a C-suite in a Fortune 500. So I never thought that a year in, I would be leaving my job, moving back home to Maryland to open up a dispensary. But what happened was right out of school, my mind was working in finance and economics. That's the way I was thinking. And I remember seeing all the time on mainstream finance media outlets, in magazines like Time Magazine, seeing on CNBC, CNN specials from Dr. Gupta about cannabis and how big the industry would be and all of the opportunity around it. That really interested me at the time because I also was raised by an entrepreneurial woman who raised me with the entrepreneurial spirit and a spirit of building wealth within our family and also being able to teach others about it. So I saw that opportunity within the cannabis industry. So for me, in the beginning, my interest started there. It started with, wow, I've never seen numbers like this in a brand new emerging industry. And I knew that in an industry like that, eventually people like me, regular people, I didn't grow up with, a silver spoon or anything like that. Regular people would get priced out eventually. But on the ground floor level, there's always opportunity. I wasn't even thinking about the social justice and the impact that this industry had on the Black community at the time. I was more so thinking, okay, I need to get in early before it blows up and companies, I'm simply priced out and I can't get in. So I looked at the way that the industry was structured, which was so different than anything I had seen. And I had been exposed to a lot of businesses at this point working in investment banking. It was so different in the aspect that it's federally illegal. And I was just kind of enamored by how every state had its own regulations around how it was governed and how it would be regulated. So that was so super interesting to me. I was like, wow, this is sophisticated. This is extremely complicated. It's not a typical industry. And for me, that was really, really intriguing. It made me want to be a part of it even more. So I started looking at first the state I was in, Atlanta, Georgia, and I realized nothing was happening there at the time. So this is 2014. Like I said, fresh out of college, I'm 22. I then look at my next state that I had resources and opportunity, which was Maryland. And I realized Maryland had actually just passed legislation that created their medical cannabis program. And in it, it said that they had to license companies by 2016. That let me know that I had an opportunity window right there for those 2 years to somehow win a license. I didn't really understand the process at the time, but I knew I had a window there. I went to the best entrepreneur I knew at the time, my mother, and presented her with this opportunity to be able to get into the industry early, be a part of the first round of licensees in the state. And with her connections as a dentist, so as a medical practitioner, we were able to solicit a third partner who is an oral surgeon and works as the head of oral surgery at a hospital in Prince George's County. And the three of us put together a small group and applied for these licenses. I had no idea what I was doing. I was very young, competing against people who were much older and much more experienced than me. However, I knew how to connect with others that had the skills that I did not. And I was able to build a team that ultimately was successful in winning a dispensary license in Maryland. So now we are in 2016. we have won the license, you feel like you're on top of the world, but really that's when the hard work really begins. So at this point, Maryland had not really implemented anything to assist minority applicants or applicants that might be qualified, that might qualify as social equity, as what we know now as social equity applicants. We didn't have that term in 2016 when we won the license, and that was not implemented in Maryland's laws. So if you have been following this industry since then, you may remember there was a big uproar in Maryland about uh, there was not a lot of minority participation, especially at the cultivation and manufacturing level. And also, if you understand this industry, those two licenses, especially in limited license states on the East Coast, especially even in Massachusetts, cultivation and processing are very valuable licenses. They the piece of paper after you win, you probably could sell for a few $1 million. And then once you have a facility with equipment, I mean, and you're producing cannabis, and honestly, the demand can never keep up. These things are worth 30, 40, sometimes upwards of $50 million. So very competitive, very sought after. And in Maryland, no minorities were awarded these licenses. And out of 102 dispensary licenses, there are about 5 Black licensees, I believe. And or there were more, but 5 are open. And the rest had to sell their licenses for various reasons. Couldn't find real estate, couldn't raise the money, partnerships fell apart, different reasons that companies fall apart. So that happened in Maryland. So we were very fortunate to be able to acquire our property. We own our building. We were very fortunate to be able to open. We bootstrapped the entire process with very, very small investments from friends and family. So we have a very unique story. A lot of people have not had that same experience that look like me. So I feel fortunate to be able to sit here, tell you my story, and help inspire others, and then as well as create resources for other people to follow in my footsteps. Like I said, we were awarded a license in December 2016. We opened our doors in September 2018. Very long process. Um, it was grueling and difficult. And I'd say the most difficult things that happen from the time that you win a license to the time that you open are, making sure you're raising the proper funds, especially if it's your first time. Likely you're not gonna, you'll underestimate the amount of money you will have to spend to get up and running, as well as be competitive with larger entities that you're in the market with. It's very expensive to acquire your opening inventory and keep up with that demand, as well as payroll and all of these things. And then, as most of you know, we have a tax burden that is just ginormous. So it is definitely grueling in the beginning, but once you get on, on a roll, these businesses really are. I mean, they're just really unique, and they are structured in a way that you can scale if you can get around the license restrictions and all of that. So yeah, the hardest things to get up and running are definitely capital. And then last thing is real estate. Um, Real estate is one of the only ways that in most states, and including in Mass, that they can kind of restrict where you or if you can get open from the local level. In Massachusetts, there's a lot more local control than in most states. So that is unique. Most states don't give local municipalities hardly any control. And it's also like this in California, there's a lot of local control. In Maryland, there's hardly any local control, but what they do have control over is zoning, which ultimately in Maryland kept a lot of people from opening. So I talked a lot about my journey. Like I said, I want to give you a little bit about what I believe social equity should look like, and social justice reform should look like in cannabis as legalization comes on the forefront. So first and foremost, I believe, it's really crazy to me that we're seeing these laws come, even here in Maryland. Medical cannabis is legal. I'm able to do every day something that someone is still locked up for. So first and foremost, we should be freeing all prisoners with nonviolent cannabis crimes. We need to expunge their records, and then we need to help them with reentry into society. You can't just put these people back on the street with no assistance. It's supposed to be a reform system, and we need to actually help these people as they reenter into our society. Number two, I believe we have to use the tax revenue that's generated to reinvest in communities. I think that these two things need to be at the forefront, not talking about social equity within the industry and getting Black people in the industry. Not all Black people want to run cannabis businesses, but what they do need is to have the rights of the wrongs of the cannabis industry reversed. We need reinvestment into our communities. We need to take a look at all the families that have been torn apart and see how we can help rebuild them. We need to invest in schools, infrastructure, job and skills training, workforce development. We can look into other programs that do this. This already exists, but this needs to be happening from cannabis tax revenue. Next, we can look at ownership and social equity in the industry after those two things are done. So I believe there needs to be a loan fund for social equity applicants. They need capital after they are awarded the license so that they are not taken advantage of by people who do have capital who would use someone like me as a front. Like I said, I have a unique story. I was fortunate. I was able to get my business up and running, and now I have value so I can do things without having to, sell my soul to someone with money. But I think that that's something we have to provide social equity applicants after they've gotten to the point that they get a license. They need low interest to no interest loans to be able to enter the industry. There should always be a social equity preference or some type of set aside, a license set aside, like in Massachusetts, the delivery licenses have a set aside period for social equity people, like applicants. And I believe that's how it should be somehow in every space. And maybe even co-op licenses, accelerator programs, incubator programs, so that people can pool their resources. And I think that's a great way to help minority applicants grow and scale quickly and together. Next, I believe that companies, a lot of times we put the earnest on companies to be able to pay for these things. And I don't think necessarily the earnest should be on the company. They pay their taxes, and those taxes should contribute to the causes. I think companies can choose to do whatever they want, but to require, a company to pay 1 or 2% of their revenue into a program, in my opinion, is sometimes a little predatory, especially when you're paying taxes. This tax revenue should do that, not diverting the tax revenue to law enforcement and then having the companies pay for the equity programs. I don't think that's fair. So that's something else. And then lastly, I believe that we should require cities and towns to be equitable as well as at the state level. So we should require cities to develop their own loan funds and to develop their own local communities as well as at the state level. Some states do this better than others. I think Oakland in California is awesome at this. They have a lot of programs specifically for social equity applicants. Massachusetts, you guys do it as well. So I want to see that more in other states. So I think long-term, we're going to see this industry take a turn once we get to federal legalization, which some people are saying they believe is going to happen quicker now. I believe we're still a good 5 to 7 years out. And even after that, we're still years out from interstate commerce. So we're going to see the industry look like how it is now for a little while. And then I believe from there, once we start to see the plant become commoditized a little bit, you'll see retail and brands become king. So you're already seeing some big MSOs switch to that model. They're putting more emphasis on their brands and really building out their brand identities and coming out with different product lines and really building out their store models and coming out with flagship designs. So I think that that's going to be the new direction of the industry. And even that co-op model that I mentioned could be kind of a new way to help people get into the industry and, I mean, develop brands that, you know, you might be able to get in for less than $100,000 and build a brand that could be worth, you know, a huge brand in cannabis right now is Cookies, and it's worth almost $1 billion. And it's a brand at the end of the day. They barely own licenses. They do partnerships and deals with people. And that can be started with less than $100,000 with the co-op program. So that's why I think equity is extremely important. It could allow people who usually wouldn't have the opportunity to build immense wealth within the industry. I'm very fortunate to have been able to get in early and to be able to talk to people like you about this, hear your questions, and help you in your journey. So if anybody is interested in kind of following me and my journey in the industry, and I share a lot about what I'm doing and what I know, I'm always trying to help people. You can follow me. I'm most active on Instagram. And I know this is your law conference, and I might not be the most professional or anything, but I'm honest and real. And, you know, I'm a real person, and I want to share with you. So you can follow me on Instagram at I am Hope So Dope. You can follow my website at hopewiseman.com. Yeah, I'm excited to grow in this industry. I'm excited to hear from all the other presenters as well, but that's my story. That's my take on the growth of the industry in the future, as well as what I believe social equity should look like in this industry. So thank you, everybody.
Thank you so much for that presentation. Very interesting journey for sure. So thank you for that. And now we will turn it over to Kay Doyle.
Good morning, everyone. Thank you for taking time on Saturday morning to come and listen to this excellent presentation. And I'm so grateful to Jay Wexler and BU Law Review for putting it together. Hope Wiseman is an incredibly tough act to follow, but I'll try to do myself justice. As Professor Wexler mentioned, I helped to run, certainly didn't run all by myself, the Department of Public Health medical marijuana program starting in 2013, and later was appointed to the Massachusetts Cannabis Control Commission. And so in the course of that, I became the longest running Massachusetts cannabis regulator, which I didn't even realize until my fellow commissioner, Britta McBride, pointed it out the other day on Twitter. So what I'd like to do is just jump into a time machine, take us back to 2016, and talk about the lessons that at least I learned from the implementation of the cannabis program, and hopefully help fellow regulators across the nation, you know, welcome to the party, New Jersey, that's my home state, as they look to implement their own cannabis programs, because it is a very difficult task. And I just want to stop for a moment and say, credit to Hope Wiseman. I mean, this is an incredibly difficult industry to get into for anyone, because you have all the problems of a small business with the added color that your product is illegal on the federal level. And there are a lot of restrictions on banking and access to capital that there wouldn't be for any other small business, not to mention other restrictions that affect farmers that I'll talk about in a little bit. So the fact that she has done so incredibly well, despite the obstacles in her way, is an inspiration. And I hope people, you know, take comfort in that and feel inspired to do amazing things on their own. The amazing thing that I had to do a few years ago was try to implement a regulatory program in a remarkably short period of time. So back in November of 2016, Massachusetts voters approved question 4, which was brilliantly drafted by my friend, Commissioner Shalene Title, and my co-presenter, Adam Fine, with others obviously helping. After that was passed, the legislature, a month later, decided to extend the deadlines that were involved in the original question, because there was concern that it hadn't actually integrated with existing Massachusetts law, and that there just wasn't enough time to do all the requirements in question 4 in the time allotted. So what they did was extend everything by 6 months, every deadline by 6 months, and then essentially announced their intention to amend some of the acts. And one of the substantive things they did at that same time, which had a profound effect, was they took away a zoning exemption for agriculture that normally applies to any other plant that you tried to grow. And the effect that that had, and Hope mentioned zoning in Maryland, the effect that that had was to provide total control to municipalities over where to put cannabis related businesses in their community. And the effect that that had, in combination with really good intentions by many local officials, was that it became very difficult for farmers to get in on this business, because what happened in well-meaning communities that actually wanted to open their doors to cannabis businesses was the easiest way to get through town meeting, which is the way Massachusetts towns under a certain size pass their local laws. The best way to get a law allowing cannabis businesses through was simply to amend their existing medical marijuana zoning to allow cannabis related businesses for adult use. The problem was that in many communities who had been rather frightened by medical marijuana when it came out in 2012 was that they zoned it in the industrial district. And it's actually amazing timing that we all just saw what an industrial district looks like last weekend when the presidential campaign for President Trump had a press conference at one. And you saw the kind of businesses that tend to be there. They're businesses like a landscaping company that may have things that are smelly or unsightly, or a bookstore, you know, that sells adult books that people may not want to have on the main street of their community. These are basically businesses that get tucked away where people can't see them. The problem is they are also not where farming land typically is, especially in an older state like Massachusetts. So by essentially promoting a necessity to get marijuana local laws passed, they did it in the most expedient way possible, which was to put them in industrial zones where there was no farming land available. The exception to that was in Western Massachusetts, where people really made an effort to try and get opportunities for their local farmers. So I just want to recognize the efforts that were made by some of the Western Massachusetts towns like Sheffield to allow this. But it's something that I want to caution states around the nation that are looking to implement their own laws. If you are passing this law and you're supporting this law because you want to help farmers be part of this industry, which is, after all, about the cultivation of plants, you need to take a careful look at zoning laws and tax laws and recognize that the US Department of Agriculture places restrictions on what farmers are able to do and will cut off services and grants to farmers that engage in marijuana production. And they won't just cut off services and grants to the marijuana part of your farm. They will wipe it out altogether. You are no longer welcome to participate in USDA programs. So we need to take a careful look at how we're encouraging farmers to participate in this industry and make sure that our own laws are not getting in their way. So that was lesson number one for me. As much as I'm very excited about farming, you need to be very thoughtful about how to implement your industry in a way that allows farmers to participate. The next issue that we have is the passage of Chapter 55 of the Acts of 2017, which was the legislature's amended version of the question for ballot initiative. It made some changes and it implemented the law into other Massachusetts laws and did a light overhaul of the medical marijuana ballot question, because the medical marijuana ballot question was quite short and small and didn't get into really the details of the medical marijuana program. DPH did an amazing job, again, on a ridiculously short deadline to pass comprehensive regulations for medical marijuana. So the law made some changes. It took the program away from the Treasurer's Department and essentially made us a little balloon on our own, similar to the Gaming Commission. The good part about that is we had independence. The bad part about that is there was no existing infrastructure to walk into. So you had 5 commissioners, 3 of whom were lawyers, in cubicles in Ashburton Place, which is our state administrative offices, no support staff whatsoever, and a very short period of time, even with that 6-month deadline, to pass regulations regulating an entire industry. So that's July of 2017. In August of 2017, the Cannabis Advisory Board was appointed. And then in question 4, it was 15 members from various, stakeholder groups. It inflated during the legislative process to 25 members. 15 is already pretty unwieldy. 25 is really unwieldy. And with the open meeting laws, it creates real problems in getting them together and being able to take action. But in 2017, these volunteers who are not getting paid a cent pulled together with us to help us meet our incredibly short deadlines and really helped us craft regulations. So first, shout out to those amazing volunteers who helped us do that. Their insights, and they're coming from different parts of the community, really helped us shape our regulations. And I'm so grateful for the work that they did. So they were appointed 1 month before the Cannabis Control Commission. The Cannabis Control Commissioners, of which I am one, were appointed in September 2017. And our lovely chairman, Steve Hoffman, met with me to talk about getting these regulations done. And the deadline in the statute was March 2018, which overall, is about 6 months or so. Doesn't seem terrible, but if you're a regulatory attorney, you know that a typical regulatory process is usually more like 12 to 18 months. So this was very short. I then had to break it to him that not only was that short, but if we wanted to do a normal rulemaking process, we really only had 2 months because there are certain regulatory requirements in Massachusetts about publishing and public hearings and allowing people to have a voice. That meant that we had to get everything done by December, not March. The only way around that was to do emergency regulations, which would deprive people really of their opportunity to have a say after reviewing the draft regulations until the regulations were already in place. When you have emergency regulations, they go into effect immediately, and then everybody gets to talk about them and decide whether or not changes can be made. We didn't want to do that. The cannabis issue can be dramatic enough as it is. We wanted to make the rulemaking process ordinary and transparent, which meant we had to get to work incredibly quickly. So in October of 2017, we launched listening sessions and we traveled around the state. Again, no staff, just 5 of us driving around the state trying to listen to what everybody had to say. And again, thank you to all the people that came out because you gave us some really great ideas that ended up showing up in the regulations. So I hope you recognized your concepts when you saw them in the regulations. We managed to get the draft regulations done in 2017 in December. That meant basically 2 months of not sleeping for Commissioner McBride and myself because we were the only attorneys that had that kind of drafting experience to put those regulations together. The issue with the cannabis industry is its complexity. There is many interests because it encompasses agriculture, manufacturing, food and drug safety, laboratory standards, packaging, security, the list goes on and on and on. And the problem is a lot of the time, these interests compete with each other and conflict with each other. So as an example, if you, as for health and safety reasons, want to prevent children from accessing a product, you require that it is put in child-proof packaging, which, let's face it, we all know it's adult-proof packaging. I mean, it's so hard to get those things open. So we are already creating right there a problem for seniors with dexterity issues. They're not going to be able to get into the product, and they're the ones it's intended for. So apart from the patient access issue, you also have the issue that when you're talking about childproof packaging, you're often talking about creating layers and layers of plastic. And that's an environmental problem. So you're seeing, again, another conflict. You're competing interests with each other. The other issue then becomes, well, let's look at sustainable packaging. Can we require sustainable packaging? Well, sustainable packaging is wonderful, but it can also be pricey. And there you're creating a market access issue. We don't want to make this business so expensive that people can't get into it. But when you're answering to the various stakeholders, we need to keep children safe. We want to protect the environment. We want to make these places secure. You're often adding layers and layers of expense for small business, which again creates an equity problem because you're creating these market access barriers. If you make the business so expensive to run that only incredibly well-funded businesses can do it, in an environment where capital is limited because there are not, the abilities to get normal banking, normal loans, et cetera, you're relying on private equity capital, and private equity capital often doesn't invest in all parts of the community. Wish it would, but it doesn't. So all of these things tend to compete with each other, and we're trying to figure them out in a space of 2 months. So one thing I would take away from that is when you're looking at these new states coming in, if you can give your regulators a way to have additional time to do a very thoughtful regulatory process, recognizing the local conditions of your state, take that opportunity. There may need to be an option to do a safety valve where you allow existing medical operators to open, but do it in a way that doesn't allow them the opportunity to completely capture the market, because you want to leave that space open for small businesses. And personally, I'd love to see a requirement for medical operators to open recreationally to have some sort of equity opportunity. Now, as Hope says, you don't want to add too much expense to people's businesses because they're already dealing with a very expensive situation. But perhaps if they could do something that demonstrates they're committed to equity and incubation program, something like that, to allow them to open earlier, that would create that balance and give the regulators room to draft regulations in a reasonable period of time while still providing access to consumers who may wish to partake before that period of time elapses. So we roll on to March 2018. Miraculously, we got the final regulations published, and we're very pleased with ourselves for that because it was a miracle. In April 2018, there was a process allowing priority applicants to be designated. Now, what priority applicants are either medical marijuana operators or folks that had been disproportionately impacted by the war on drugs. And Commissioner Doyle, who spoke yesterday, created a great way of determining that would survive a constitutional challenge. The problem is the legislature only allowed it a set 2 weeks for those certifications to be made. So the lesson I learned from that is if you do that, it's going to limit who benefits from the program because people aren't going to know about it in time to actually apply for it. So if you want to do something like that, don't put a set time period in your statutes. Statutes are difficult to change. Allow the regulators to designate the time period because regulators have more flexibility and they can pass regulations faster than legislation can be passed. So don't put something that needs to be flexible in a statute or a constitutional amendment because they're difficult to change. So the licensing process began, and we discovered that the volume of license applications was so incredible that it created a volume problem, just like you do on the highway. There may not be a crash or something creating a giant traffic jam. It's just there are a lot of people trying to get somewhere. Thanksgiving's coming up. We've all seen Thanksgiving-related traffic. And that's exactly what happened here. We just had an incredible volume of applications, but it has a disproportionate impact on small businesses because they were having to have carrying costs because the way the application process was implemented, you essentially had to have your property interest straight away. Personally, I prefer the way we did it at the Department of Public Health, where we phased it and the property interest wasn't necessary to be designated until the very end, because I think that cuts down on the carrying costs for all businesses, but most particularly impacted small businesses. But, it is what it is. What we did, and again, thanks to someone writing in and suggesting a way to solve the problem, a local farmer had an attorney write us in a letter suggesting that perhaps we provide, in addition to priority applicants being highlighted, and priority applicants essentially go to the head of the line. General applicants just wait in the order that their applications were filed, they are dealt with. The farmer's lawyer suggested that we add an additional priority group within the general applicants. And that gave birth to the expedition policy, which prioritized within the general application group businesses that the legislation wanted to favor, such as cultivators, outdoor cultivators, craft cooperatives, independent laboratories. We want testing to be available and safe, as well as businesses owned by women, veterans, and people of color. And so that actually really started to make a difference in terms of making sure that small businesses did get their applications processed within a reasonable amount of time before going under from the sheer weight of their carrying costs. And in November of 2018, the first stores opened. And the lessons that we learned from that is really need to communicate with your local officials. about local conditions because one of the stores was also on the only access road to the local Walmart. And we permitted them to open the week of Thanksgiving. And what in a non-pandemic era happens the week of Thanksgiving other than Thanksgiving? Black Friday. So we had one of the only stores selling recreational cannabis on the Eastern Seaboard open the same week as Black Friday. Sorry, I've just gotten a message that my microphone is cutting in and out. I'm afraid there's multiple streaming happening at my house right now, so I apologize. There's nothing blocking it, but I'll try to speak louder. So the long and short story of it is you need to make sure that you really understand local conditions. Otherwise, you end up with massive traffic jams and other problems related to your site that you just may not have anticipated. So that brings me to the end of my talk and the lessons that I learned during my time as Cannabis Commissioner, which are proactively listen to people who disagree with you. If you stay in your bubble, you're not going to learn anything. You need to listen to industry, you need to listen to stakeholders, even the ones who are trying to tell you that you're doing everything wrong, because some of what they say may actually help you do your job better. Closely examine the incentives you're creating, the agricultural zoning issue being an example of that. Recognize the need that you're going to need to amend legislation, regulations, and guidance to keep up with changing conditions. Don't be precious about it. Don't have pride of authorship. Be humble and realize that you can't see the future and sometimes you need to adjust. Don't put language somewhere that needs to change if you put it somewhere where it's difficult to change, as I just discussed. And then last, collaborate, collaborate, collaborate. There are so many other agencies that are going to interweave with yours. DPH, the Department of Agriculture, there are just many other agencies that need to get involved with the cannabis industry, need to help set standards that will keep people safe, whether they're working there or whether they're consuming the process. And there needs to be a better job in all state governments of working with each other so that we can do a better job ourselves. And with that, I will go back to Professor Wexler and our next speaker. Apologize for the microphone issues.
Thank you so much for that presentation. I have that first group of regulations here, so you just want to look at what they did in 2 months. It's pretty extraordinary. And helping clients navigate those regulations is our next speaker, Adam Fine. Turn it over to you, Adam.
Great, and Professor Wexler, thank you. Hopefully everyone can hear me okay. I have had some computer issues over the time period, so please let me know, one of the panelists, if people can't hear me or if I sound like a robot, which has happened, unfortunately, in the past, pretty recently. So anyway, I'm really happy to be here today. I really want to thank Professor Wexler and the Boston University Law Review, really the Boston University. I've had the pleasure of teaching at or guest appearing at Professor Wexler's classes, or one class, class usually a semester, and K. Doyle has as well. And Boston University, I think is really a leader. We have law graduates from Boston University that are on our staff that are just exceptional. So I really think when it comes to marijuana law and kind of policy, really great to have kind of the academic partner as a stakeholder in the Commonwealth of Massachusetts. So I wanted to talk today, it was really good to go after Kay because she did a great job kind of giving the background from the regulator perspective. And I'm going to kind of give the background from the practitioner's perspective and try not to be too critical because it's easy. It's really easy to be critical. And I think stakeholders in the industry, whether we're operators or consultants or anybody that's participating that's not a regulator, I don't think people realize how difficult the job is, and especially in the Commonwealth of Massachusetts, which I'll talk about, given what the legislature did to question for. I was one of the, in addition to representing, our firm represents probably now thousands of marijuana businesses throughout the United States. I was fortunate enough to be working in the Commonwealth of Massachusetts since 2012, and when medical passed question 3, and watched Doyle and others implement that law. And interestingly, you know, there was a very slow rollout of the medical program. But where it ended was actually in a pretty good place from a regulatory standpoint and a pretty efficient place. It took a while to get there. I think by the time legalization happened, we only had 38 stores open, or registered marijuana dispensaries, which we called them at the time. But we actually had a pretty reasonable set of regulations. We had I think they were 37 pages. Maybe Kay could correct me if I'm wrong there. But you could carry them around and you could understand them and you could really kind of speak to them. And I think what we've seen, and I'll just, you know, as we talk about the evolution of the law in the Commonwealth, and I think for other states, Kay said, welcome New Jersey, South Dakota, Montana, Arizona, you know, others that we just saw in this election, there is a lot of lessons to learn from the Commonwealth. And they're not, I don't want to be too critical, though I'm going to be a little critical, so I'm going to have that disclaimer. There's a lot of positive from the Commonwealth, and then I think there's a lot of things to learn. And one of the things I think we need to, I hope that we learn, that other states learn, is that, you know, we're in a state in cannabis overall, but particularly in the Commonwealth, where I think we are over-regulating marijuana. We know that marijuana is less harmful than alcohol. We know that we kind of have a pretty good idea of the harms, although we don't want to get ahead of it. And so you know, there's really that question is why is it that we have such stringent regulations? You know, when we talk about medical, we had, I think, 37 pages of regulations. We've seen this commission in the Commonwealth of Massachusetts. You know, they've written a lot of regulations. We do now have hundreds of pages of regulations, touching upon so many different aspects of what it, you know, being part of regulating the businesses. We have social equity, which I think is absolutely key piece of the regulators' jobs. But what it's created is a high barrier to enter the marketplace. And a lot of, you know, I talk about regulations from a scope problem, but also a certainty problem. And federal law used to be, what, you know, in 2012, even before the Cole Memorandum, the primary thing that was on everybody's mind when you were entering the industry was, you know, what is the risk here under federal law? You know, a real fear, a palpable fear of federal intervention, of getting arrested, of having your bank account frozen, your property seized. All of these things that kept many people out of the industry, including most law firms. You know, we were in it, but you know, I remember having kind of, and I was a bit late to the party in 2012, but others that are watching can speak to it. They really had skin in the game. I can't say I had skin in the game, but others did, and that was the fear, right? That the feds are going to come in and that your whole life, everything you've invested in, all this risk, that was the barrier to entry. We've seen that barrier to entry lessen over time, which is great. But what I think what's replaced that barrier has been the state regulatory schemes. And there's reasons for that, I think. And I kind of want to pause here because I want to go back to 2016 because we're 4 years out from the election. So I'm going to, as someone who does not great with technology, I'm going to do some screen shares and show some videos. And just to frame it, it's going to be some of the advertisements, both on the yes on 4 side and the no on 4 side. I think that's a really good place to start as we talk about kind of where we are in the Commonwealth, and why we're in that place. So let me dare I try here to share my screen and see if I can pull this off. So hang on. Indulge me for a moment here. Let's see here. Oh, don't have that yet. Bear with me. Sorry, everybody. If I can't do it, I won't do it, but I'm hoping I can. Can people see the screen now? Hopefully. Let's try this.
Yes, we can see it.
Okay, great. Thank you. All right, so here's the first ad. I'll pull it full screen here and And let me know if there's no sound.
I was a Boston PD cop, and now as a professor, I believe yes on 4 is a smart choice to protect families. Let me explain. Question 4 requires strict product labeling and child-proof packaging and bans advertising directed at kids. And question 4 bans consuming marijuana in public. It will tax and regulate marijuana for adults 21 and over, bringing millions in revenue for schools or law enforcement. Vote yes on 4. Smart regulations protecting families.
Let's get out of there. All right, now I'm going to go for a no ad. Let's play that.
Question 4 would allow thousands of pot shops and marijuana operators throughout
Do those who
Massachusetts
say living well
in
can't be
neighborhoods like
delicious?
yours. Shops that sell pot edibles that look like candy and high-potency
I
marijuana.
say, bisque,
In pro-pot
weed.
states,
Live
incidents
well,
of drug
don't
driving and
compromise,
fatal
eat
car
right.
accidents are up.
Oh,
More pot shops than McDonald's and
Every time
Starbucks
President Trump and his
combined.
campaign file a
Higher
dumb new
potency,
lawsuit or
dangerous
spread a new lie
drivers.
about voter
It's the
fraud,
reason
they
health
quickly get
professionals
batted
are
down,
urging
and
you
this
to
will shock
vote
you.
no
It's all a
on
giant
4.
grift. For more on this, it's time
Question
for a closer
4
look.
would allow thousands of pot shops and marijuana operators throughout Massachusetts
Well,
in
President-
neighborhoods like yours. Shops that sell pot edibles that look like candy and high-potency
Hopefully everyone saw
marijuana.
that, and I'm gonna keep
In
it.
pro-pot states, incidents of drug driving and fatal car accidents are up. More pot shops than McDonald's and Starbucks combined. Higher potency, dangerous drivers. It's the reason health professionals are urging you to vote no on 4.
Okay, and then I got one more, and we will we'll wrap it up after.
The number is now fast approaching 250,000, and the CDC's new
All right, everybody. Here's the last one.
I'm not sure exactly what the benefits of creating a marijuana industry here in Massachusetts are.
This ballot proposal is not just about allowing adults to use marijuana in the privacy of their own homes.
It's about the edibles. That's what this is all about. And this is going to be targeted at young people. And our young people already have enough challenges.
These young people do not need easier access to controlled substances.
Legalizing marijuana for recreational purposes will drive a stake, it will drive a hole, it will stretch that safety net in the cities and towns in our Commonwealth.
There are more marijuana shops in Colorado than there are Starbucks and 7-Elevens combined.
No, I do not support the legalization of marijuana.
We already allow access for medical purposes, and we've already decriminalized possession so that today folks aren't being arrested for using or possessing small amounts of marijuana.
Go out and vote no on the legalization of marijuana and let them know what the harmful consequences to this Commonwealth will be should this ballot question ever pass.
So hopefully everyone saw those videos. I'm sorry about the technology issues, but I wanted to show those because I go back and I look at them and I actually can't believe it. Our politicians, and there were 120 of them, and you saw really that coalition, and it was a coalition of our elected officials who all got in that room, and they were very dramatic, and really that wasn't, and we looked at that Kevin ad with the kid, seeing his mother coming out of the store with a huge grocery bag of, edibles and marijuana and a bong hanging out of it. I mean, it was so absurd. And at the time, I wondered if people saw it as absurd. By the way, I think the politicians are still contesting the election. No, I'm just kidding. But, I really think that there was the opposition in the Commonwealth was not so much the people. It was, there was a subset of it, but it really was a political coalition that were behind the times. Really, I kind of laugh when who signed off on that Kevin advertisement, because it seemed to me to be so absurd. But we had a lot of money being raised by politicians and a lot of by our lawmakers, and Sheldon Adelson, a casino magnate, and that was kind of the combination, and that's what we got, which I think did a disservice as we talk about the implementation of the law but really kind of frames why in many ways we are where we are in Massachusetts. So let's talk. I want to kind of talk about that, and please, someone let me know if I'm running out of time, because Jay, please chime in if I'm going on too long. But where are we in Mass? We have a state where, let me talk about the positive first, which is we have a very good public health and public safety record. We can kind of thank our regulators. Really the regulations allow for that. I think the fact that okay, I've got a little bit of time. The fact that we have a strong set of regulations and a thorough regulators really kind of enabled us to kind of have a really safe rollout of our program. We don't have overproduction like we see in other states, and that's a big win. Overproduction is not good for businesses. It's not good for the illicit market. But I think there's a lot of challenges in the Commonwealth and the state. We'll talk about them: slow rollout, high prices of marijuana, a really kind of a struggling rollout of the equity program, a lack of capital, and still have because of all those factors, a illicit marketplace that still exists. So I don't have a lot of time, so I want to kind of just get through some talking points. I think in Massachusetts, we have, I talked about that kind of high regulatory burden and the impact on businesses. And why do we have that? And I think we have that for three kind of primary reasons. And these are kind of obvious, but I just want to state them. The law matters, the regulations matter, and the implementations of the regulations really matter. And we can kind of see, our lawmakers, Kay mentioned, kind of took question 4, which had a lot of good aspects to it. And maybe they weren't happy, they didn't win, but they took the law and they changed it. And they made some fundamental changes which have really impacted where we are today in terms of slow rollout. So I just want to highlight a few of those. Kay Doyle already mentioned it. We have the commission structure that was under the Treasurer's office. We wanted it under the Treasurer's office because Deb Goldberg was ready to go. She had already regulated alcohol in the Commonwealth. And that was going to be just a commissioner and 2 associate commissioners. What we got was an independent body at the start from the ground up, and five commissioners. So I think that created, building, one piece of advice is don't start from scratch. I think that was a mistake in the Commonwealth. Starting from scratch put an enormous burden on the commissioners, and particularly the executive director, who has to answer to 5 bosses to implement a law. So I think that's one thing. Local control, question 4 had really, I think, appropriate level of local control. When the lawmakers took the law and changed it, they added a host community agreement requirement, and that was incredibly problematic in terms of just allowing businesses to be excluded, even if they were fitting within particular zones. So I think the host community agreements, in addition, it's kind of created an environment ripe for corruption and abuse in terms of that 3% of gross revenues that cities or towns can get. They're often trying to exceed that. There was no license cap. This is one thing that isn't talked about enough. There's no license cap actually contemplated in question 4, and it came into the new law really kind of not really being thought out too much. And I think unfortunately what that resulted is in the regulators spending a lot of the time and attention rather than focusing on things that matter, on trying to look at license cap violations when we don't even have an industry built out yet. So I think that took away a lot of the mind share, from the focus of the commissioners, and it was never studied. I think there's a lack of capital in the industry, and the license cap issue really, the way the regulations they're so broadly construed now, it makes it very, very difficult to partner in the Commonwealth. It's a highly risky endeavor because the commission likes to give out big fines if they think there's a license cap violations, and the regulations still are not very clear on that issue. But I think one of the improvements from question 4 was to the new law was the social equity program. And I know, Jay, I think I'm running out of time here, but I want to talk just a little bit about the social equity program and how we, some of the issues with it. And I think, it's been mentioned before, Yeah, I think that's been a big disappointment. There's kind of been, I think, a false narrative in the Commonwealth that, there's big marijuana and big marijuana is responsible for shutting out social equity applicants. And I don't think that's the case. I think that, the big marijuana, certainly we want to be cognizant of big businesses shutting out little businesses, but I think the biggest issue is the lack of capital and an inability. We can write all the regulations we want, but we got to figure out ways to bring capital to these businesses. When we talk about areas of disproportionate impact, when we talk about Hispanic and Black populations that were most undisputably the most impacted by not only marijuana laws but the war on drugs in general. There's been kind of a move, a very broad focus, and I my personal opinion is to really focus in on those people most impacted, and that starts with this fund. Other speakers talked about that fund. Our law doesn't have the fund. The lawmakers didn't put it in, and we weren't able to put it in as part of question 4. I think adding the fund will be a big plus. And just because I'm out of time, I want to talk about one final thing, which is a big part of the barrier to entry in the Commonwealth, which is the suitability. We can talk all we want about social equity. We can talk about expungements, but one of the I think unfortunate aspects or difficult aspects of the implementation of this law is the high suitability standards, which really kind of expanded upon or went from a regulatory perspective in the Commonwealth, went beyond what the statute calls for. And the statute, just to in Massachusetts, just to lay it out for folks, really talks about whether or not you have a felony or not. That is what it talks about when it talks about suitability. It's concerned with felony criminal convictions, and I think that bars a lot of people. There's a lot of people with felony convictions that probably should be able to participate in the industry, but the regulations shouldn't take it a step further. And I'll just give some examples of where I think probably a lot of work could be done in the Commonwealth to fix some of these issues. Non-felony weapons violations. That's a presumptive negative suitability in the Commonwealth. What does that mean? Does that mean a misdemeanor? Somebody had a misdemeanor, nunchucks or knives. None of that is in the statute, but the regulators have kind of taken it a step further and saying, not sure why, but that there's those offenses. Firearm related crimes. We know that obviously firearm related crimes are serious. But I can tell you as a former public defender, we saw a lot of instances where they would find guns that had nothing to do with the drugs that were found, and they would charge people with the drug crime. So there's a lot kind of in between there. I think probably the most interesting one is the regulations say the applicants or licensees if the prior actions posed would likely pose a risk to public health or safety or welfare, and the risk posed relates to or likely would relate to the operation of a marijuana establishment. And in the Commonwealth of Massachusetts, we've seen this suitability review. A lot of applicants get stuck in suitability, and their applications can languish. And we saw that with, I think it was Lee Daniels, when she was an applicant, that language, I think, Kate can correct me if I'm wrong, for hundreds of days in the application process while the commissioners tried to figure out whether or not there were suitability issues. So I think a strong takeaway is I would hope that we get back to kind of what the law says and not have regulations that exceed it. And I think suitability is a great example where the regulations as implemented really exceed what was intended statutorily. I'm sorry that this is a bit rushed, but I think really the takeaway is we want to work towards reducing regulations, particularly around suitability, having a social equity fund, whatever it takes to get that passed. I think that's very key. And overall, encourage or look at regulations and figure out ways to reduce the regulatory burden as we recognize, like we saw in that commercial, that commercial is not going to happen. And we see in states such as Oklahoma and others where there's a low regulatory burden, we don't see much of a difference in terms of the end, where we end up from a public health and public safety perspective. So how over time can we work to reduce the regulations and reduce those barrier to entry. And so I'm sorry this is so rushed, partly due to my technology issues, but there's a lot to talk about here, and I look forward to hearing from the other panelists. But love to see over time our regulatory burden get diminished, and not excluding people, that haven't been convicted of crimes, or where their crimes or don't really relate to marijuana businesses. Because we know, just to sum up, we know that when we talk about disproportionate impact, especially on race, we're talking about all crimes. We know that there's disproportionate impact in the criminal justice system, and there's more arrests and convictions disproportionately for people of color. So I'll wrap that up, and thank you, Professor Wexler.
Thank you so much for that. And our final speaker, Sean Keely, will now speak about cannabis and the Massachusetts legislature.
Thank you, Jay. I just wanted to say that the best part about going last is I had a chance to revise my resume and send it to Hope while waiting to speak. But I also have two confessions. I've never tried marijuana, which my oldest daughter, who's now a junior at BU, thinks is hysterical that I'm participating in a conference about marijuana. My second confession is that I don't like legislating by initiative petition. I don't think people fully understand what's in front of them, and I think that gets borne out by the videos Adam showed. And this comes from somebody who used to write the summaries that appeared on the ballots for the Attorney General. I think people most often are voting for an idea and not really the nitty-gritty language that's going to end up being on the statute book and governing the area of law. And sometimes, the difficulties come up because the drafting, the actual terms of the statute haven't been put through a deliberative process. Rather, they're written by advocates who are passionate about one side of it, but they're putting forth something that's their ideal rather than something that's worked out through a deliberative and process that includes compromise on all sides. And so one of the examples that I often bring up with my students is an initiative petition several years ago that banned the trapping of beavers. The animal cruelty advocates came forth and said, let's stop trapping beavers. Everybody agreed and put the petition into law. And then a few years later, the beaver population exploded, and lots of rivers and streams were dammed, and several towns got flooded. So the legislature had to quickly reverse engines on the drafting on the beaver initiative petition. The basic point, though, behind the initiative petition is that legislatures aren't democratic enough. They give citizens more power. There's 24 states out there that have an initiative process, and Massachusetts has had one since 1918. And typically they're in place because the legislature fails to act, and there's a need to express the public will and do an end run around the legislature. And it seems to have worked very well with the marijuana industry, especially here in Massachusetts. The advocates for legalization have gone through 3 stages, and I think they systematically worked through legalization in a very thoughtful way, starting with medical marijuana and decriminalizing small amounts as far as possession, and then moving on to the larger issue of full recreational marijuana. But what I'm going to take today is that the maybe an unpopular position, and that is that the legislature really did a good job here. And I think it's going to be in direct contrast to Adam, and I wish we had a little bit more time so that we could have more of a debate about it. But that, and I wanted to go through just really the theory behind when a legislature is acting well and when it is producing something that is useful for the people of its state, and kind of apply those lessons to how the legislature operated in the marijuana context, especially when it was taking the dramatic step of delaying the implementation of Question 4 and then giving itself 6 months to create a new statute or to create amendments to the Question 4 law. And I'm going to rely heavily today, and probably in my article as well, on Alan Rosenthal, who was one of the most astute observers of legislatures in recent history. And he would ask in several of his books, but most particularly in the book Engines of Democracy, how well do legislatures work and how do we measure it? And the first measure would be, how do people view the legislature? And as you may have gotten from Adam's presentation, probably not great. Most people have a fairly low view of legislatures, their own legislature. People certainly have a very low view of Congress at this point, and for many good reasons. The second measure was the laws that the legislature produces, and then it becomes a question of quality or quantity. And as far as quality goes, what exactly is good policy or law? And that always depends on where you sit. You may have a law that's loved by environmentalists and hated by factory owners and people who are looking for greater economic development opportunities. And Rosenthal's third point is that perhaps the best measure of whether a legislature is working well is how good is its process. And as he said, it's the key mechanism in our representative democracy for deciding what public policy should be. Another source for deciding what the effectiveness is from a book called Congress by Paul Quirk and Sarah Binder. And they ask if the legislature gives reasonably proportionate weight to the various interests that are coming into the debate, public opinion, the various interest groups, other sources of policy demands. They then ask, does it deliberate intelligently and with relevant evidence? Next, does it face up to the real effects of policy choices? And finally, does it avoid gridlock? And I think the legislature in this case actually demonstrated several of those measures of effectiveness. And finally, I'll go back to Rosenthal for a moment. In his book, Heavy Lifting, he surveyed 5 legislatures and asked the members, among the 3 principal aspects of legislatures, one being representing constituents and constituencies, the other being lawmaking, and the third being balancing the power of the executive. What was it that they did well? And 88% of the members of the legislature said that they represented their constituents and their constituencies very well. You have a step down to 69% who said lawmaking was something that they did well. And then finally, you take another dramatic step down and they say only 41% of them said that balancing the power of the executive was something that they did well. So they do an excellent job of representing their constituents and the various constituencies that they represent. The second, lawmaking is a very hard process, and that's not a bug, it's a feature. It's supposed to be difficult. It is there in every legislature to prevent bad law from happening. This sometimes can be frustrating, having seen many, many good proposals that I've written and backed die in the legislature. It is frustrating, but we all have to keep in mind that there's a lot of concerns in play, and that the legislature needs to study problems and issues and gain a mastery of the subject. And they have to spend a tremendous amount of time deliberating and negotiating specific terms. And all of this shows the need for the committee, the legislative committee, where most of this work is done. And as Rosenthal points out, if the committee is bypassed or weak, deliberation is going to be shortchanged and the end product is not going to be as good. And finally, with balancing out the executive, it's typically done well. And oftentimes legislators spend too much time thinking about the next bill rather than thinking about what they've passed and how it's working and whether or not the administrators who are trying to implement the law have the right policy, the right people, the right budget. And so in the Massachusetts experience, I was reviewing all of the news reports from 2016, 2017 to jog my memory about the great marijuana debates. And I came across one article where the travel writer Rick Steves, who I really like listening to and watching on TV, he's always somewhere great in Europe, called the legislature reactionary. He was one of the proponents of question 4, and he came to Boston to basically say that the legislators were giving into fear and tired arguments. And I think from an outside perspective, you could get that impression. First of all, the law went into place and the legislature immediately moved to keep several key aspects of it from taking effect for 6 months, and then spent the 6 months floating different ideas. And at times, I think the advocates for question 4 rightfully were worried that the legislature was going to completely overhaul, if not insert poison pills and undermine the law totally. But I think the behavior of the legislature was totally normal given Rosenthal's formulation. And I just wanted to run through each of those. I'll try and wrap up in about 5 minutes. First of all, representing their districts and constituencies, I think this is the best explanation for why the legislature didn't take the issue up on its own. It waited to see how the voters went in the 2 previous ballot questions, and they certainly wanted to see how they were going to vote in the legalization of recreational marijuana. I mean, there was a high level of support for medical marijuana at the ballot box. There was a lower amount of support for decriminalizing possession. And all the polls showed that it was a very close split amongst the voters in 2016 as to how they were going to vote on recreational marijuana. I think one example, though, and Kay already brought it up, is this agricultural change that was made at the end of 2016. And it kind of exemplifies what the legislature was looking at in 2016. And the agricultural change was made because a farmer in Plimpton, and I'm in the town of Hanson. Plimpton is just 2 towns over that way. It's mostly cranberry bogs. It's very agricultural. It's a tiny town. It's maybe 3,500 people, 4,000 people. And the farmer wanted to start growing marijuana, and he claimed that there was an allowance for this in the agricultural regulations, and it divided the entire town. There's a 5-member board of selectmen down there. 3 of them supported the farmer, 2 of them and the town manager did not. The local law enforcement did not support it. And there was a huge debate amongst the people of the town of Plimpton. And ultimately, the local legislators got involved and they filed a bill to try and stop this from happening, just in order to put to rest this question as to whether or not farms could just start growing marijuana as an agricultural product. So I think I think this shows that the legislators aren't hearing from just the average voter who's thinking about whether marijuana should be legal or not. Rather, they're hearing more from the local town officials and especially selectmen, select women, the city councilors, the law enforcement officials, and many other law enforcement officials, such as the elected district attorneys and the elected sheriffs from each county. These are important voices that the legislators are going to hear from. So it certainly was not an easy choice as to whether or not to support this ballot question. And I think the nature of legislators is that unless there is a critical mass of support, they're going to take the more conservative position and prefer to keep the status quo as opposed to changing a major policy like legalizing recreational marijuana. I know some of my panelists may dispute this, but I think the legislators tried very hard to show deference to the voters and to keep the spirit of the statute. This is something that Senate President Rosenberg said over and over and over again, that that's what his goal was. After the election took place and question 4 passed, Charlie Baker, who was as you saw from that commercial, an outspoken opponent of the question, grudgingly said that he was going to support the spirit of the voters and not try and overturn it, but that the changes needed to be made. And they needed to be made in order to balance out all of the interests, many of which perhaps were not part of the original drafting of the statute. And the second part is lawmaking. The advocates said that the law was well researched and written, and I have no doubt that it was. I think it was of very high quality. On the other hand, it wasn't put through that deliberative process that is true of a legislature. And I've written hundreds of bills, and not one of them have passed without scrutiny by a lot of other people, a lot of other committees, and a lot of revisions. And one advocate that I came across during a rally said that the legislature had 20 years to pass something, and now the voters passed something and the legislators declared it as crap, and they had abrogated any right to change the law because of their previous inaction. And I think that misses the mark. I mean, true, the legislature had a chance to make revisions to question 4 before it went to the ballot to the voters, but given the above discussion, it was probably prudent for them to see how the vote went. And secondly, in 2016, there were only a few months left to the formal sessions when roll call votes could be taken up, and that means controversial issues could be dealt with. Most complicated pieces of legislation take far longer than 6-7 months. And at that point, most of the bills were in their final stages. And most importantly, and unfortunately I'm running out of time, but the legislature was not structurally set up for considering cannabis policy. As Kay pointed out, there's the issue could have been spread across 9 committees, all of which had a business that relates to marijuana, revenue, public safety, judiciary, public health, healthcare, finance, economic development, environment and agriculture, and 2 ways and means committees. And also one group that had done serious study on the subject, the Special Senate Committee, led by a fairly liberal member of the Senate, Senator Lewis, raised a lot of problems in their research that the legislature understood it had to address before it could come up with a final product. So after the 2016 delay of some of question 4, the legislature set out a really ambitious agenda. They said that they were going to delay things by 6 months and that they would have their revisions in 6 months. It took them 7, but for the legislature, or any legislature, that's moving at lightning speed. And I think that shows that, one aspect of the effectiveness that I talked about was that lack of gridlock. Even with a lot of people who were fundamentally opposed to the legalization of recreational marijuana, they were able to move a major bill through the legislature and put some changes into effect. I think also it's it was an extremely complicated bill in that, as Senator Jalen pointed out, she was one of the co-chairs of the the Marijuana Policy Committee, that it wasn't just one bill that they were working on, or even three bills: the voters bill, the Senate bill, the House bill. But it was also necessary to take into account all the previous initiative petitions and all the regulations previously passed by the Department of Public Health. And so they did a tremendous job, I think, on in three areas. That is rethinking the tax structure, which I know we can debate about, but as the counsel of the Revenue Committee for a couple of years, tax law is a hard thing to work through, and it has a lot of policy implications. And the idea that the tax structure needed to make a balance between getting enough money to run the program while not driving people to the black market, that was a hard thing to work through. The other one was local control. And it necessitated the legislature come up with some provisions that were going to keep the local officials happy and feel as though they had a stake in this and that they had some power over how their community was going to be shaped. And finally, and I just wanted to point this out, balancing the executive may be the most important thing that they were trying to attempt, and that had to do with the Cannabis Control Commission. Massachusetts has a split executive, unlike a lot of states. Our executive branch is five officials, all popularly elected statewide: the governor, the attorney general, the treasurer, the secretary of state, and the auditor. One of the things the advocates kept arguing during this whole time was that the legislature should leave the law that the voters passed alone, allow the commission to do its work and see how things shook out, and then the legislature could give them some advice. And I think that was backwards. The legislature leaves, agencies take direction from the legislature, and legislatures often leave discretion to the agency, especially when necessary, but they weren't going to do this with a brand new agency, especially when they had no idea who was going to get appointed. And so they wanted to give some stake to the various executive officers, not just the treasurer, but also to the governor and the attorney general. And so I see my time is out, but I would say that the legislature's work was good, it was necessary, and it's ongoing. It's something that the legislature continues to work on. And I know a couple of my students, I didn't get a chance to talk about social equity, but a couple of my students have been working with the legislature on social equity issues, and hopefully we can continue to improve the law. Thank you.
Awesome. Thanks so much, John, for that presentation, and to everybody for your presentations. It's 11 o'clock, but I'm going to exercise my moderator organizer prerogative to extend our period a little. The conference has a long break until the next panel. So if panelists can stick around for another 10, 15 minutes to talk, I hope we can do that. If you can't, of course, feel free to take off. And I know it's Saturday and there are many things to do, but I thought maybe I'd start by asking if anybody on the panel wanted to address anything that somebody else on the panel had said. I know there was a little kind of interaction between Adam and Kay, and then Sean and Adam, and I don't know if anybody's interested in responding or clarifying anything in response to something that you might have heard.
Well, yeah, I mean, and Sean, I appreciate that presentation, and it's interesting because we didn't coordinate beforehand, but I always, just to respond, exactly what Sean said, I've always felt that there were some improvements to the law, but I thought legislatively, and I still really believe this, that we talk about these barriers to entry, and lawmakers, I think in many ways, put off the implementation of the program, and setting up a brand new industry, I think really set the Commonwealth back. So I just think, yes, our advocates, we do like our law, and I think we're biased, but I think I think that was a big part of why we have some of the issues that we have today. And the lawmakers have been unwilling. They've not amended the law, I don't believe at all. And they've kind of shown an unwillingness to intervene. And I think one of the interventions they could have was putting parameters in to the regulators, right, to define more what they can do and how do we keep over-regulation from being a problem. I think that would be an important legislative role. That's what I'd like to see, focusing on social equity and focusing on kind of giving the boundaries to regulators.
And I think also considering how, as Sean mentioned, how quickly the legislature had to work. I think, it's a few years later, it's a good opportunity to go and revisit and learn from the conditions that have developed since then. So I have filed an incredibly long report on host community agreements, which I hope some poor staffer has actually read up at the State House. I'm not kidding. It's almost 800 pages. So the poor things. But I think it does bear examining and realizing that, the language was based on the Gaming Commission language regarding host community agreements, and casinos are massive operations, much different than a small cannabis store. So I think it's worth looking at how things rolled out here and figuring out whether or not we should clarify the language around host community agreements, because we certainly don't want to have language that internally conflicts with the stated goals of the legislation, which is in fact to promote small businesses within the Commonwealth.
Yeah, and I think that's all valid, and I hopefully, as the Marijuana Policy Commission committee has now been renamed the Cannabis Policy Committee, they've got a staff of 3 or 4 that are just terrific in the House, and I know a couple in the Senate as well. But they're examining probably 60, 70 bills each session. And hopefully some of these are going to start moving, especially in the social equity space. I think what we've seen is, again, you have a couple of good examples, and Hope mentioned Oakland. And I know that's one of the places that they've been looking for inspiration. But trying to figure out the right balance in Massachusetts it's been difficult. I mean, there's a lot to take into consideration. But just going back to the local control for a sec, one of the things about the question 4 language was that it really put a process into place that didn't exist in Massachusetts, and that was to have a town-wide referendum in order to either allow or disallow. And I know what they were trying to get at, but that didn't exist in Massachusetts. And so really the legislature had to step in. The community agreements do throw up a barrier of entry. And I think that was by design. I think that was something that a lot of local officials wanted and demanded that the legislature put into place. And to the effect that that's keeping businesses out, that needs to be re-examined and amended.
I have a question for Hope, actually. I don't know.
Oh, sure.
Oh yeah, go ahead.
Yeah, sure.
So I'm very curious because we're kind of in our bubble here in Massachusetts, but as an operator, and I know as someone who cares about the social equity, do you feel that and maybe I shouldn't put you on the spot here, but
Okay.
how do you feel about the regulatory kind of burden? I don't call it burden, but compliance issue, and do you feel like you have kind of regulatory certainty in how the regulations are applied to your business, or is that something that's constantly? Because one of the things we see in the Commonwealth is that not only there's a lot of regulations, but there's a lot of punitive things if you do things wrong, and we've seen big fines, for example, $500,000 fines. So that kind of adds to the cost. So I'm kind of curious just on Maryland and how you deal with that as a business.
Yeah.
It's particularly probably hard for social equity. I know you're not in that, but go ahead.
Yeah, no, it's very difficult. Everything that you said, Adam, I experienced myself. I think one of the biggest things is that, they hire these inspectors to implement these regulations, but it's somewhat subjective, when they're interpreting these laws. or the regulations, and that can be confusing and difficult to, you might hear about something your competitor is doing, and then you do the same thing and you get fined for it, and you're like, what's going on, but it's the way that that inspector has interpreted the regulations. So I think that states have to figure out a way to make that uniform, talk about these things, not be so quick to immediately fine companies. I think Maryland has done an okay job with that. All of that's public record, so you can go on the Maryland website and see everyone who has been fined and why. I think that I don't want to say that any companies have been targeted or anything like that, but when you leave things up to any subjective reasoning, you're going to have some inspectors that are more aggressive than others. So, like for me, we've been fined before for small things, not large fines, but we've been fined before, and I know of people who have gone through the same issues we've been through who have not been fined. I don't think it was targeted towards me. However, I do feel like my inspector just interpreted the laws a little bit more aggressively. So I think that does make it difficult for minority-owned companies, for social equity companies, when they have no experience. And if you're competing against an MSO that has been up and running in 23 states, and here you are, brand new, you get this license, you're so excited about the industry, and you make a mistake like you accidentally input somebody, if it's a medical license, their patient number wrong, and you get a $2,000 fine for that. It's like, I think that there has to be some way to kind of work through these issues, a warning program. I think that those things should be addressed because mistakes are inevitable in any business. That is inevitable almost in any business. So holding people to unrealistic expectations that their inventory has to be perfect and you have over 1,000 SKUs. I mean, it's things like that need to be considered. And I feel like resources need to be provided to help coach and mentor social equity applicants through the regulation and compliance process.
Thanks so much. We do have one question that came in through the Q&A, and it intersects with something I'm interested in. So I'll ask it. The question is about home grow and whether, because New Jersey just recently in their proposed law have proposed to ban home grow. And we talked about this at a panel yesterday with Shalene Title and Bo Kilmer, and talked about whether home grow is an equity issue. And I was wondering why states ban home grow, and one of the arguments was that the industry might, want to. It's obviously something that could cut into the business, And so I was wondering, as somebody who's both an entrepreneur, Hope, and somebody who's concerned with equity, what's your view about home grow?
I normally shy away from this question, just letting you know. But I think it's great. I kind of feel I'm torn on both sides. I definitely think it is a social equity access issue. Some people, one, can't afford to go into these dispensaries, and two, sometimes it's just an access, like actual location access issue. So I think home grow for people who really need the medicine is really important. That being said, like you said, I'm a businesswoman. Like I told you guys before, I think about, economics and finance. I don't like the idea of you being able to grow something at home that I have an exclusive license to sell. But I think that there needs to be some regulation. A lot of people talk about home grow and then being able to get that cannabis into dispensaries. I don't like that at all. I think that if it's home grow, it needs to be used for personal use only. In DC, I don't know if anyone knows about DC laws. So DC has passed recreational, but they don't have an actual program set up. So there's this gifting thing that goes on in DC that's very odd. So you have to find ways to make sure to avoid that. And what I mean by that gifting thing is you're allowed to grow cannabis in DC in your home. And then you're not allowed to sell it for monetary value, but you can gift it. So there are even storefronts on popular streets in DC that will sell you a $60 consultation and gift you an eighth of cannabis.
Right,
So,
you buy a T-shirt and it comes with a bag of weed.
Yeah,
Hey,
that's-
didn't Massachusetts have to deal with that too for a while?
really,
It was short-lived. Yeah, it was short-lived in Massachusetts.
how did you kill it? Because I'm so
Well,
confused.
probably-
Like I said, there's storefronts now that are doing it in DC.
Yeah, I think I have to. I don't know your enabling law, but our law was pretty clear. You could gift it, but it really, it really wouldn't. It's a real stretch under the law. It wasn't like a plausible loophole.
Yes.
I mean, I'm sure it still exists. Look, the illicit market exists in the Commonwealth, but I don't. Okay, maybe you saw it more on the regulatory side, but not something we hear about too much anymore, at least.
Yeah, in the very beginning, before the dispensaries were open, I think you saw it more. Yeah, there was, we call them contingent sales if you go into a store and buy a vaporizer that's $15 and all of a sudden you buy a $45 identical vaporizer and get an amount of cannabis with it. Like, we're gifting the cannabis to you. Not really. So that shouldn't be permitted. I'm sure, as Adam said, it does still go on. But, we want to make sure that the products received by the public are actually safe and have gone through the safety testing that is required in the Commonwealth. And I have to give a shout out to the Department of Public Health, because they were one of the first states to actually do a comprehensive safety testing. And if you were around when we were implementing that, the results that we were seeing initially on, the heavy metal contaminants in the plants was slightly terrifying. I had no idea that was an issue at the time. So I'm very grateful to the toxicologists and the folks at the Department of Public Health who, really worked on that issue and created a safer environment for patients and consumers.
Well, at this point, I think we do need to wrap it up. I want to thank all of our awesome panelists for their presentation and for the conversation this morning. We will break now as the conference will resume at 12 o'clock with panel number 7, which is about agriculture, the environment, and energy.
Very important.
Yeah, right. People sometimes forget about the environmental impacts of marijuana. So I wanted to make sure we have a panel on that. And so that's coming up at noon. And so I hope to see some of you there. And again, thank you so much for coming. Have a great rest of the day.
Thanks, Jay.
Thanks, everyone.
Thank you, everyone.